Let's pick up where you left off there, Aisha. Hunter Biden could be held in contempt of Congress after defying a GOP congressional subpoena Wednesday. For more on this, we're joined by criminal defense attorney Brian Claypool. Nobody better for insight. Brian, let's dive in. So Hunter Biden, for those that weren't watching this week, was subpoenaed to come and give a deposition behind closed doors to the House committee. Instead, he defied that and showed up instead and held a press conference. What do you make of it?
Hey, Griff, happy holidays. Yeah, so Hunter Biden defies a subpoena. What can the House Oversight Committee do? They can do one of two things. They send this off to the DOJ and see if the DOJ will try to enforce the subpoena. We know that's not going to happen given the last couple of years with how the DOJ has handled investigations. The only other option, Griff, is that a federal lawsuit can be filed by the House Oversight Committee. The problem with that is you'd have to wait months to have a federal judge issue an order to compel Hunter Biden to show up and testify. That might not even happen until after the election happens.
Hey, Brian, put your shoes in Abby Lowell's position. If you were Hunter Biden's attorney, would you have allowed him to go up on the Hill and make these public statements? It's pretty well known, you don't want your client talking. Some have pointed out that among the things he did say about saying he was being wrongfully pursued and he did nothing wrong, he did not say that his father, President Joe Biden, then Vice President, did not take money.
Yeah, Griff, I think it's a huge mistake for Hunter Biden to be saying anything. He's already been indicted 12 times, and he is exposing himself to potential perjury. What do I mean by that? House Oversight Committee has a lot of documents. They have financial records, and they have a lot of other documentation. So if Hunter Biden goes in and makes comments, and then he actually goes to testify before a public hearing and says something that's at odds with the evidence that the Oversight Committee has, he could be charged with perjury. But look, Griff, at the end of the day, I think this impeachment inquiry is warranted. We need to know whether there's any wrongdoing by President Biden. And look, remember, Griff, on December 7, 2015, former President Biden went to Ukraine and asked for Shokin, the prosecutor, to be fired, where he's going to withhold $1 billion in loans to Ukraine. So, and another thing too, this guy, Steve Sherwin, we need to have his deposition taken. He's Hunter's partner in Rose Seneca. Mm-hmm. He had over 20 visits to the White House. What's that about? We need to unpack that. As voters, we have a right to know whether the White House was cowering favors to help Hunter make money.
A lot more we need to learn as he faces those tax evasion charges in California. We'll see where that goes. Brian, before we let you go, I want to get your insight on the former president, Donald Trump, and the move by Special Counsel Jack Smith to appeal to the Supreme Court to expedite a hearing on whether or not he has immunity in that case. It has tremendous implications possibly for the campaign trail. What do you make of it?
Yeah, I think this is a move that favors President Trump. Why? Because the Supreme Court, Griff, they're not going to even hear this until probably sometime in the spring. And by the way, the Supreme Court agreed to hear this. That is a huge move. That means it's important. That means they want to weigh in on this. That's not going to take place until the spring. A ruling's probably not going to come out until the summer. Why is that important? Because they're not going to be, Smith is not going to be able to go through with this prosecution of President Trump till well after the election. And this federal law, 1512, I think the Supreme Court is going to deem that law, it's an obstruction of an official proceeding that is not going to apply to the prosecution of Trump and possibly others who have been prosecuted. That law was developed from the Enron scandal. Remember Enron shredding documents? Sure. Really has nothing to do with this type of alleged wrongdoing.
And just in the last 30 seconds we've got, it's a very fascinating scenario. I believe, correct me if I'm wrong, unprecedented. Is there a chance that the Supreme Court decides to not really get too deeply weighing in on this because of the precedent it would set in terms of dragging the court into the gray area of political favoritism?
Griff, I don't think so. I think this is more clear to the U.S. Supreme Court, or they would not have agreed to hear this case. I really think they're going to look at this carefully, and I'll give my prediction. I think that the Supreme Court is going to rule on this, and I think they're going to find that this federal law that carries 20 years in prison for these alleged wrongdoing on January 6th is not applicable. They're going to look at the history of the law. What's the legislative intent of this law? And it just arguably doesn't apply here. And I think that's what they're going to find. And that's going to create chaos. Can Trump be prosecuted? Likely not. Others convicted, are they going to get reduced sentences? They're going to have to do plea bargains on like a crime called incitement. And Griff, that holds a lot less penalty time than under 1512.
Prosecution pushing for a March 4th trial date. We'll see if it starts then or not. Brian Claypool, as always, thank you for the great insight.
Thank you, Griff.
Aisha?